Hello ladies and gentlemen, welcome back to my YouTube channel. So this is another video, part of the criminal law series. I've already done the first appearance, so if you want to know a bit about what first appearance involves, then I will leave the link to that video for you to go and watch, because today we're going to be talking all about the trial. Now, as I said, the trial date, so on the first appearance, you will have a date if you're pleaded not guilty, and that means that your case will go on trial. And on your first appearance, there's going to be a form completed, a case management form, and on that form, there is a general guidance. Sometimes magistrates tend to be very strict as to the time frame that you give them. So for example, if I've got a witness X and I'm going to be cross-examining for 15 minutes, if I've put down 15 minutes, they may actually stop me on 15 minute spots and tell me your time is up. But sometimes they tend to be a bit flexible. And that's because what you do, they will add up all those minutes and they will give you an estimate. Okay, this is a half-day trial, this is a full-day trial, or it could be 2 or 3 day trial, depending on how long it takes you to examine and cross-examine. Okay, but first things first, what is a trial? A trial means that the defendant, so the person who allegedly committed a criminal offence, says, I did not do it. And that means that the prosecution, the Crown Prosecution Service, the person who will be in court on behalf of the CPS, the Crown Prosecution Service, has to prove to court beyond reasonable doubt that the defendant, the person who allegedly committed the offence, did it. And the threshold for that is that the magistrate, the judge, has to be sure that you committed that offence. If they're not sure, that means they need to find you not guilty. So what is the trial process? So you go in the court, the defendant will be in the deck. If you're a defendant, then you will have to go in the deck, yeah? And the prosecutor will open the case. They will read a bit about the facts, give a bit the context of it, and that will be for the prosecution to actually open the case. Now, the defendants normally, the defense counsel doesn't normally do an opening statement. It's just for the prosecutor. It gives a bit of a context, and then it will be for the prosecutor to call their witnesses. So let's say they will call witness A. The witness will come in, it will be sworn in there. So that could be in different ways. There could be an affirmation, depends on what the beliefs are, the religious belief. It may be the Bible, the Quran. So there is different ways to be sworn before the court, and the court has all that before them. Yeah, but I know over time I've spoken to my clients, and they will be very sometimes obsessed with how they sworn. It's like if it's the Bible, or for example, knowing that person is Muslim and he takes an affirmation rather than swearing by the Quran, they say he's been lying because he hasn't sworn the Quran. But for the judge, it really doesn't matter, it doesn't have an impact, and even if it does, he's not allowed to say anything. So it's just part of the process. Do not make any conclusions from it, because it's not conclusive. It's part of the process. And I remember when I was doing my training, one of the lawyers actually said to me, I never quite understood what's the essence of it. Of course, they need to tell the truth. So if they know the truth and they're concealing it, so they're not saying it, that will be a separate criminal offence. But that's part of the process, okay? So they will be sworn, and then the prosecutor will be asking questions. So it will be for the prosecutor to ask those questions. Now, if you are the person that's going to be being prosecuted, do not be alarmed. The prosecution puts forward their case. They're going to be asking, you're going to be hear what that witness seen or how they perceive it. If it's the victim themselves, they will be saying those things. It may be completely different to what your version of facts is, and do not start either sometimes you get clients that they get very agitated or angry. So it needs to be explained to you that it is the prosecution case, and that's what they're gonna do. So the prosecutor will be asking open questions. That's what we call examination in chief. They can't lead the witness. So for example, they can't tell you, you did have a coffee this morning, didn't you? That is a leading question, because what I'm seeking from you is to tell me, yes, I did have a coffee. Rather, the prosecutor, what it's going to be doing is going to ask you, what did you have for breakfast? Okay, so it's an open question. It's very open, and there is an art into how you ask those questions. So So those will be the open questions, examination in chief for the prosecutor. Then it will be for the counsel, the defense counsel, to cross-examine. When it comes into cross-examination, it is all about lead. You are leading your witness, yeah? So sometimes you may have an open question just to allow the narrative, but it needs to be very carefully done. So your defense counsel will be actually asking leading questions. So if you told them, for example, it did not hit you with, so if you threw, let's say, I had once a case that the husband allegedly threw hot mac and cheese from the microwave. So he said that he threw it towards the wall because he got angry, but he never aimed towards his wife. So it was a domestic violence case. So an example of that will be, his hand was not directed towards you, wasn't it? He took the mac and cheese from the microwave and he turned on his left, didn't he? So all those are actually leading questions that is going to build upon to the point that, so I'm not going to ask you directly, he didn't aim at you or he didn't injure you, he didn't do that to you, because automatically what that witness would have told me is that, no, that's what he did. So I'm trying to get from that witness, from the victim themselves, in this case, this example that I'm telling you, that perhaps his demeanor or his direction wasn't facing her, yeah? So you're going to go into that and you go into quite detail to be able to get this evidence from them. And those are oral evidence. So it's what they tell, it's live evidence, is what they say in court. So that's about cross-examination. And then it will be time for re-examination. So if there is any point that came across from my cross-examination, then the prosecutor will be doing re-examination. Normally they say there's no further questions, and that will be the end of one witness. Now, this process will be repeated for all witnesses, including the person who's been prosecuted. So if you have 15 witnesses, that will be done 15 times. The same if you have expert evidence. If you have an expert, the same thing, the same principle. Examination in chief, cross-examination and re-examination. Okay, so that will be repeated according to the number of witnesses that you have for the trial. Once all that is done, then it will be time for closing submissions. Closing submissions, it's about gathering all this evidence and using perhaps case law or the legal points that they may arise during the trial itself, and you're addressing the court, telling them what you would like them to find. So you perhaps guiding them. I had once a hate crime case. There were 5 counts, and there was this, I can't remember the wording because I've done so many cases and it's been quite some time. I've been on a mat leave for quite some time now. So essentially there was this term that was used, and the police officer said it was used in a very racist connotation, and I had to go and find case law saying that that it's dangerous to broaden up anything said, assumingly that it had a negative connotation just because it's how you perceived it. So the court had to be very careful, because there is also freedom of speech. So we have to be careful how much we narrow that down. And the court found me in favour, and he's been found not guilty on 5 counts. So that's what's going to happen in closing submissions. And if you're lucky enough as a counsel, you will have lunchtime to prepare and go through your evidence and prepare your closing submissions. So, or sometimes you have to do it whilst you're actually taking notes of the evidence given in court. So then the judge may actually take some time to deliberate, to go through the evidence and think about it. The magistrates, sometimes there could be 3 of them or 2, so they have to go through that, and they will come back and they will let you know. They will read, there is a paper that they read, and they tell you, they give a bit of summary of the facts as to what they've heard, and then at the end they will tell you whether they're guilty or not guilty. If you've been found not guilty, that will be the end of your case, so you will get out of there and that will be done and dusted. Now if you're found guilty, then there will be a sentence, but that's a separate video to watch. So essentially it will be for the court then to decide what will be your sentence, but your defense counsel will definitely assist the court by proceeding with what is called plea mitigation. So they're going to actually extract from your criminal offence any mitigating factors. Now, a defense is very different from plea mitigation, and sometimes you can get confused. But I'm going to leave all that part of the sentence video. If you do have any questions about the trial, leave them in the comment section down below. I really wanted to find a mock courtroom, or even courtroom itself, that is willing to actually give their space and do a mock trial for you to be able to watch and see the process, to actually get the feeling of it. So if you are one of them and you can actually help me to do that, I'll be more than happy to talk to you. Leave a comment down below and I will get in touch with you. That will be great, actually. So yeah, have a lovely day. I hope you understood a bit about the trial process. We only touched the surface of it. There is a lot more involved in it, but the best way to do it is actually go to magistrates court yourself and just watch the process. That's what I've done when I was practicing law, just being in court, or even before that, and get the feeling. If you're a pupil, that's a great tip. Have a wonderful day, and I will see you in my next criminal law series. Thank you for watching. Bye bye.